Hey, it's your old buddy Brian Parker. I just did another video. The last video I did was on a case called Booz and Ocwen loan servicing, and where about our convenience fees and processing fees that we all get charged every day. And it was an appellate court case saying, wait a minute, that's an FDCPA violation if it's not inside the original contract. A little background, someone asked, you mentioned something about a removal. So I'm going to quickly tell you today what the concept of removal and remand is under federal rules. That doesn't sound very exciting, but we'll give it a shot. So in the Booz case, the plaintiffs, I don't know why they did this, to be honest with you. It doesn't make any sense why the attorney did this, but they filed in a state court against Ocwen to say, hey, you're charging us all these fees. That's not part of the contract. It's an FDCPA violation. So what happened is Ocwen immediately scooped up the case and removed it to federal court. So we're going to see what that means and what we can do about that. So it was a Florida lawsuit in a state court. Ocwen took the case and removed it. So back in the day, I would always file a lot of stuff as far as foreclosures were concerned. They were state acts. Foreclosures are all state acts. But I would allege FDCPA violations just to do the best I could to keep my client in the house. And the banks love federal courts. So they'd immediately scoop up the case and send it to federal court. Federal courts were not kind to foreclosure consumer clients. I have my own theory on that, and it's sort of weird, but I don't think it would have served the country well had we'd really gotten to the bottom of why people had the right to do what they were doing. Let's leave it there. So when you are removed to federal court, you are now dealing with a federal judge and federal court and federal rules. That can or can't be your friend depending on where you're coming from. So let's take a look at what this is. So removal is only based on two things. Let me put it up there for you. Shazam. And that's a federal question jurisdiction. So if the court had original jurisdiction, what does that mean? That means if the case could have been filed originally in federal court and you had filed it in state court, then it has original jurisdiction and it can be pulled into federal court. So there's many reasons why, especially banks and corporations, like to get you into federal court. And rightfully so. They don't feel like they're getting a fair shake in state court. Frankly, because state courts are of the people. I mean, you go to state court and you may even recognize the judge. And it's a, you know, it's a very local community thing. And this big bank's out of Chicago coming down to Podunk, Florida. They're going to feel like they're hometown. And I felt that too. So they feel safer in federal court. Or diversity is the other reason. And you've got to show that there's what's called a diversity of citizenship, meaning the plaintiff and the defendant can't be from the same state, and the amount in issue has to be above $75,000. That may get changed because it's been a while like that. So here's what removal is. Shazam. Removal under 1441 is the fact that a defendant can remove a case filed in state court to federal district court if, that, as I said, the court has original jurisdiction. Most commonly, it's done through diversity jurisdiction. For me, it's done federal question. And so the timing of removing a case. So you filed a case in state court, they scoop you up into federal court. You have 30 days from the service of the initial state court pleading, meaning the time the person or defendant was served. They got 30 days. If it's a diversity action, you get 30 days from the date when it became obvious there's a diversity issue. So it could be after 30 days, but suddenly they realize all the defendants and plaintiffs aren't in the same state. So you file what's called your notice to remove, And that's on any document you file to remove. There's a removal action. There must be a notice. Most federal courts, no matter what you do, have a court form. Let me put it up there. Shazam, that's a civil cover sheet. And in this case, you can see Booz was the plaintiff, Ocwen was the defendant. They're making the request for removal. And I've tried to highlight there the basis of jurisdiction. We said there's either it's a diversity of action, a 75K, or it's a federal question. And here they checked off federal question, but I put up there the two choices you have: citizenship of the principal parties versus basis of jurisdiction. And the origin, it was removed from state court. And the cause of action, you have to put a detail what it is, and it's the FDCPA. In that case, the Booz and Glover had filed under the FDCPA against Ocwen, and now Ocwen, with their cover sheet, has removed it. So, and you attach to that sheet all the pleadings and everything that's happened in state court. So you're placing the federal court on notice how and why you're doing it. So some of the reasons why you remove, why a defendant, it's only a defendant action, remove. Shazam. A federal question, as I said, and there's a thing called a well-pled complaint. That expression's found its way into other sections of the law or proceedings or filings. Only the plaintiff's complaint, not defenses or counterclaims. So that's very important and strategic. Let me use the expression again. Back in the day, when I was a young consumer attorney making my way, I was doing whatever it took to win. It was learning, and you have to learn, you have to grow. And I was getting my butt kicked. So I started filing counterclaims, and I had this one attorney who I still see today to kind of smack me around. She took my counterclaim, which was filing an FDCPA claim against the person coming after my client, and she removed it. That's not allowed. It's only the original defendant can remove the case. So remember that. Only defendants can remove cases. I'd filed a counterclaim, so then her client became a defendant. Originally, she had sued me. So she was a plaintiff, I was a defendant. I counterclaimed back, so she removed it after claiming she was a defendant, so she has a right. Well, it's very strict. There's totally no way you are the original defendant, which you have to be, to remove it. Now she's screwed. Now, we were going at it really hard, and I was not going to be nice to her. It takes a lot to piss me off where I'm not courteous, but once I'm in that place, it's on. And all I received from her was a string of pictures of her kids, of her family situation. There were health issues. This is what I got bombarded with. Why? Because I had the right now to go after her in federal court. It's mandatory, and just charge her all these fees and probably embarrass her, because how do you not know a very simple thing when you're practicing federal attorney? But she had been so angry with me. A lot of people get angry with me. She just did this removal just to piss me off rather than being clear-headed about, oh, what can I do here? So I had her. She knew it. And I couldn't do it. The pictures, the kids' pictures and all that. I'm not going to disrupt somebody's life. By the way, I regret that I didn't smack her, because to this day, she's exactly the same person. She didn't think, well, Parker was a good guy to me. She just is the same person. So that's lawyers. So it can't come on a counterclaim. And again, it's got to be a well-pled complaint where the case arises under federal law only. If the federal question is presented on the face of the plaintiff's properly pled complaint, then it can be removed. So by the defendant. So examples are FDCPA, that you can get that removed, TILA, and FCRA. I say those three because those are the main things that we operate under as far as debt collection defense. If you don't have a federal question, you need what's called diversity of citizenship. Shazam. That means no plaintiff can share any state with the defendant. If there's what's called complete diversity, where no one's connected in the same state, you got a shot, but you also have to have the 75,000 rule. The plaintiff's good faith claim but must be for more than $75,000 exclusive of interest and costs. A lot of people try to get into federal court by adding on their attorney fees that they hope to win and the interest on the judgment. So if there's multiple plaintiffs or claims, aggregation rules apply. Only when a single plaintiff brings multiple actions. So you can't add and stack on multiple plaintiffs. It has to be one plaintiff's multiple claims add up to 75,000. So again, as is always the case in these things, removal must occur within 30 days. When I say within these things, all these counteractions, removals, they're all 30-day rules. So a removal to federal court must occur within 30 days after service of the initial pleading. Service, where you are served, however that service occurs. All defendants must join in. What do I mean? So back in the day, that's our theme today, back in the day, I'd sue everybody and the kitchen sink. So you'd have like 3 or 4 or 5 defendants. And my goal was where if I could turn it where they each recognize what their liability is and think they're going to get hit for more than they should, they'll start pointing the fingers at each other. So I've talked about this in the past. When I can get my case into the point where I just sit back and watch these idiots start fighting and producing documents that hurt the other guy but help me, that's what I want. If I've got a good faith background to do that, I always do. I love to watch these guys just help my case by fighting amongst each other. But they all must agree if it's going to be removed. If one says, nah, I don't want it removed under diversity, then it isn't removed. The forum defendant rule means the rule borrows removal on diversity grounds if any defendant is a citizen of the state where the action was filed. So if you're in Florida and Chicago guy sues you and, Illinois and Montana guy sues you, but also another Florida defendant is suing you, then you got a problem. Let me back up a second. You've sued, and you've done what Parker does, it sues everybody, and all the defendants are from different states except one, then diversity doesn't occur. If the defendant is the same as the plaintiff, diversity doesn't occur. So the removal context, a defendant sued in state court may remove on a federal question grounds if and only if the plaintiff's initial complaint includes a federal claim. It has to have a federal claim to have original jurisdiction. It could have been brought in a state claim on its own is not filed in federal court. Where you become the counter plaintiff, meaning you're the defendant, now you counterclaimed, and I'm just reiterating what I said, now you're the counter plaintiff. The counter defendant does not suddenly say, like that situation I talked to you about, that one attorney, you're not now a defendant with the rights of removal. You're never that way behind a counter claim. If after removal, so what do you do when you get there and you know you shouldn't be there, or they screwed up, or they took 31 days to do it? I've actually been there. I've had where they filed it in 31 days. I've had to file that motion. I learned a lot. So over 30 years. So if after removal the federal court finds that removal was not proper, it will remand the case back to state court. There's 2 ways that occurs. There's Suisponte. Suisponte is just another legal Latin term, which means the court itself on its own motion is saying, that ain't happening, Charlie, you're going back. Or your motion for removal. So it's sometimes a court will, and those are good courts, by the way, where they're paying attention, they will just do the work for you and save you a bunch of attorney fees and house. But I also like courts like that are paying attention. I don't have to work as hard. Removal usually occurs if the federal court lacks subject matter jurisdiction over the case, meaning it doesn't have original jurisdiction or the power to hear the case. Or there were procedural defects in the process. So if they take 31 days to remove, that's a procedural error. You can file. Now, if you wait 31 days yourself to do something about it, you can't remove. Remember the 30-day, you can't remand. So after removal, you want it back in your state court, you have to file a motion to remand, excuse me. So don't wait more than 30 days. Or if the case was not one that should have been removed to federal court in the first place, that's a basis to get it remanded back. I just did, I want to appeal, and they all say this, I just want an appeal, and I've only had one instance, a really good case, where I won on the same facts twice, my client and I, and the first time the court said, this goes right back to the state, to the other court, lower court, to work this issue out that Parker's brought up. The second time, the same case, same facts, same judge that just had an axe to grind with my client. I mean, that's a whole video in itself. That's a fun video. We take it up to the Court of Appeals, and this time the court says, I'm not doing this anymore. We're just ruling that Mr. Client wins. They didn't let it go back to trial or anything, just said that we've had enough of this. So most of the 99% of the time, it's going to remand it back. I just had appeal, and they said, Parker, you win. And that's the fun, you go get remanded back to the judge that did the bad stuff you allege. Oof, I've talked about that. So the implications in debt defense, if you choose to assert an FDCPA or TILA claim in state court, be aware that you cannot be scooped up in federal court by a counterclaim. Now, if like in the Booz case, you filed in state court, don't know why they did this, then the defendant is originally a defendant and can remove to federal court. I guess I've written for myself that it's leverage. Maybe. Removal forces the creditor into a stricter pleading regime and opens up broader discovery. I tried to force in leverage here, but I don't think you threaten someone and go, I'm going to remove it, but you can't say, hey, look, you screwed up, blah, 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 blah. Why are we wasting any further money on this? It's not going to go to federal court if we can work it out, and that's fair to say. Bottom line, a federal question exists only when the plaintiff's properly pleaded complaint invokes federal law. Okay. Remand. I mixed those two up, but remand, Shazam, 28 U.S.C. 1447C is the process which a federal court returns a case, again, Suisponte, or on your motion for removal. So how do you beat an improper removal? So an improper removal is you're sitting there in state court and you filed a federal claim against a bank or a debt collector under federal law. They remove it, and it's improper in your eyes, so you file a motion to remand, 28 U.S.C. 1447C. And again, remember the 30-day rule. It must be filed within 30 days of service of the removal notice when you received it. What's the date? Argue lack of subject matter jurisdiction and improper by the removing party. It's improper. You're automatically awarded fees and costs. 1447C expressly alters the remand order to require, that's a shall. Remember there's two types of law, you may or you shall. When it says shall, there's no alternative. When it says may, it's a suggestion. Here, it was a shall. And so you need to keep a copy of everything you're incurring, all your fees, or if you got an attorney, all the work you did, if you think you got a strong case of getting that thing remanded back. Federal courts routinely award fees in case of clearly improper removal. That's true because it's a shall. The thing about federal court I like, it's mostly black and white. You can be a good attorney articulating and persuading the court of what the law says. I guess the nuance there is this is how I interpret the law, this is how brother counsel interprets it. But they're very black and white. It's very structured in federal court. I like that. There's no nuance there. So removal statutes and fee shifting, that means, and I've cited a case, In re Willis, 663, F 3rd, 528. That's the 9th circuit. I'm not going to put the map up with all the numbered circuits, but that's generally, if you're in that area, award of fees under 1447 for improper removal is mandatory. In that case, at the lower federal level, they hadn't given the person fees, even though the statute said you shall. It's always weird to me when, especially where it's clear 2 + 2 = 4, and the court says, yeah, but 5. But it's black and white. It's not interpretation to say the law, use the law incorrectly. So that had to be filed. An appeals court had to step in and go, Charlie. So briefly, watch the 30-day clock on removal and on your remand motions. So always have a calendar. Document all your costs. And again, flag any absurd jurisdiction. Like, again, in my case where the lady removed it on my counterclaim because she was claiming now she was a defendant. That's law 101, but that's what she did. And to this day, it's between us. She never mentions it. I never mention it. I did the right thing. She doesn't recognize that. So it's all about timing. And there's a 30-day clock. So that's remand. Mostly that's removal. That's how Glover and Booz got into federal court. Again, it's usually done, especially by banks, to scare the person that filed against them. That's like a federal court. But federal court's your friend, and I find while they are uncomfortable with pro per, people that aren't represented, I've met some very strong people without an attorney, and the courts will give you leeway if you end up in federal court. So much of law is personality and fear driven, meaning the attorneys are doing it to scare you. Probably when they were in school, somebody bullied them. It's a license to bully now. It's a technique. But just take your 5 minutes and, okay, stand up and come after them because the law will set you free. We have, as you know, the killdebt.ai is coming. We're working really hard to get this done by mid-June. It's very technological based. Every time the guy that's developing for us, for you and me, I have to take what he tells me and put it into ChatGPT and say, can you put this into layman's terms for me? Because I don't understand a freaking thing that they're telling me. But this time, they gave me an update Monday morning. So I'm like, oh God, Monday. I put in ChatGPT and the ChatGPT say, good, because it keeps a running tab of all the times you enter questions. And I said, good news, it looks like you're getting ready. So we've got testing coming up on that. Hopefully the testing is by mid-June, and then we're going to off and away offering you this great service. Our members at killdebt.com will have, I think there's going to be like 50 of them, free access to this. So we can learn and get the bugs out for everybody. Now that I think about it, June 13th, we have a question and answer coming up. I believe it's 5 p.m. Eastern Standard Time.
4 p.m.
My crack staff just yelled 4 p.m. It's 4 p.m. Eastern Standard Time. And that will be a question and answer where you can ask me any question. So I've got from now until the 13th to Friday the 13th to properly know what the hell I'm talking about so I can instill confidence in you. But all it really is it's all my intellectual property. They're even creating a voice that not hearing me quite yet, but the way I talk or returning the information will be in my certain voice. So you just go, I go, oh God, you say, I got an answer, I got to get this done. Beep, boop, beep, boop, beep, boop, beep, beep. Up pops an answer based on your facts and state law, but it has the Brian Parker approach. And again, as I always say, you can go to a service and get admit, deny, admit, and then file that thing, or you can be a problem Parker and create leverage. So the AI of this will be taking me, my silly brain, but good stuff, and giving you an opportunity to quickly have the thing done for you so you don't have to, it's tough, it's difficult. We're too busy sometimes to go, okay, now go fight in federal court. So this will be your friend. This will be your, I hate to say pseudo attorney because we're not giving legal advice or anything, but it will be the next step that you need to just fill out what you need, know how to do your counter affidavit, file your letters, all those wonderful letters from Natalie's documents vault, all in my voice, quickly done for you. So someone loves this, so I'm going to do this. And don't forget, ParkerGPT is coming. It's on its way. There's the little airplane, and that's what it will be. It will be my stuff for you. All right, I took a very quick subject and lengthened it again. I hope this helps. Remember, removal and remand. Thank you very much. Bye-bye.